Here are 5 things that you should know about guilty pleas or plea bargaining. Number 1 is the fact that plea bargains are in fact negotiations. That means they are subjected to contracts law. They're governed as a formal agreement or a contract. Number 2 is when you enter into a guilty plea, 99.9% of the time you have waived all of your constitutional rights to appeal, and unless you preserve that opportunity in the plea agreement, and most state prosecutors will not allow for that. 3, sometimes, and not in all cases, a judge may accept the guilty plea but sentence you over what the recommendation of the guilty plea actually is, because though pleas are governed by contracts law, they're still called non-binding and discretionary, meaning that the judge ultimately, if a charge carries 0 to 5 years, you accept a plea that recommends 1 year in prison, that judge still can give you up to 5 years in prison. Which leads us to number 4, the fact that plea agreements are not guaranteed. Okay, and that's pretty cut and dry. And number 5, and very important, do not simply sign off on the guilty plea sentencing form that your attorney is going to present to you without reading everything and asking the questions. Remember, this is a contract. So what happens is, if you just sign off and check the boxes and you get in front of the judge and they have what's called the plea colloquy, and the judge asks you, have you been promised anything? Have you been threatened? Are you satisfied with your attorney's representation? All of this is going to be used against you later. So if the judge goes outside of the recommendation of the plea, you can't come back now and say, oh man, well, wait a second, I was threatened or I was promised, because you admitted on the state and you signed the paperwork. So ask questions, okay? And if it's something that's not clear, make sure that that's clarified on the record before you take the plea. Top 5 things.